Well, social media giants may not be able to hide behind the First Amendment when censoring users on their platforms. Supreme Court Justice Clarence Thomas says lawmakers may be able to treat big tech companies like places of public accommodation, which would reduce the power of any given platform and limit their ability to exclude or censor users. The justice argues that the public accommodation doctrine would strengthen the argument that an account is truly government controlled and creates a public forum, which was an argument used against President Trump's account back in 2019. Back in that year, President Trump was sued for blocking someone on Twitter. The court held that the 45th president violated the user's First Amendment rights by restricting their access to a public forum. However, the following year, Twitter famously banned President Trump's account in its entirety, which, as Justice Thomas points out, prevents all Twitter users from interacting with him. Now, the Supreme Court dismissed the case today as moot now that there is a new administration in the White House. With me now to discuss is Newsweek opinion editor and Edmund Burke Foundation research fellow Josh Hammer. Welcome back, Josh.
Always great to be back with you, Kara.
Great. So how important is the opinion given by Justice Thomas, even though the Twitter case itself has been dismissed as moot?
So what a day. I for one, feel vindicated. A lot of the arguments that myself, Rachel Bovard, Will Chamberlain, a lot of, my friends, colleagues at the Internet Accountability Project, those of us on kind of the big tech skeptical right, a lot of us, the arguments that we've been making now for the past year or two have now been bestowed a greater imprimatur of legitimacy by the man who was probably the sharpest legal mind in the conservative world in this country. So it's a really fabulous day. The procedural posture here, as you mentioned, the case was properly dismissed as moot by simple dint of the fact that President Trump is no longer president. But there's so much to unpack here, and we obviously have such limited time. But one thing that I've been saying for a little while now, and I go back to kind of the big tech takedown of the New York Post with respect to the Hunter Biden reporting last October. I wrote a piece in late October just before the election basically saying what to do after big tech's Pearl Harbor attack. I said Pearl Harbor attack on the New York Post. And in that article, what I said was, Section 230, which is kind of the most common talking point for those on the tech skeptical right, is an important tool, but we need to be thinking actually bigger than that. And at that time, I said that the common carrier regulatory framework, which kind of goes back to the railroad barons of the late 1800s, that was kind of when this really kind of came into use with respect to kind of railroads and canals. The basic idea here is that if you're a common carrier, you're not able to kind of discriminate willy-nilly. You basically have to kind of let everyone on. And I basically said that this had more teeth here, that we should talk about this for tech companies. And, a lot of people, especially kind of our more libertarian-leaning friends and kind of the build your own Google crowd said, no, this is silly. What are you doing? But Justice Thomas now has basically said that this looks very legit. Look, it's not a huge deal until like an actual case or controversy gets properly before the court and they actually kind of discuss the merits of this. But at a bare minimum, here's the key point here. This is a signal to Republicans in both Congress and the state legislatures for how to chart a path forward from here. That's really what it is.
Yeah, you're exactly right on that front. And I know you argue that we should even think bigger than Section 230. I know that was a big talking point on the right, at least towards the end of President Trump's administration. But interesting to know, Justice Clarence Thomas was in some way suggesting that perhaps Section 230 may be unconstitutional. Talk to me a little bit about that and why he would make that argument.
Yeah, so he drops his footnote towards the end of his concurrence. He cites to a Eugene Volokh blog post. Eugene Volokh has been kind of one of the leading kind of libertarian conservative legal scholars of the past 15, 20 years at UCLA School of Law. And it's a blog post from this past January. And what Professor Volokh argues in the blog post, and Justice Thomas cites this argument favorably, so we can presume that he thinks it's probably right. He basically says that if state governments, so state legislatures, are enacting their own laws, trying to kind of affirmatively protect online speech, kind of similar to what Ron DeSantis is at least talking about doing down in Florida, for example. If state laws are doing this, but Section 230 at a federal level kind of steps in, what lawyers would say it preempts those state laws, it basically nullifies them and makes them that there'll be a null set, that they basically won't be able to kind of come into effect. That in and of itself might actually be unconstitutional. It's a really intriguing line of argument. Section 230, Justice Thomas he has written about this before. This is not kind of his first rodeo in the world of Section 230. He's very sympathetic to the notion that this overarching notion that Section 230 allows private companies to just discriminate however they want. He has implied that he thinks that is an erroneous interpretation of the statutory framework. So look, I can't say enough good things about Clarence Thomas. My former boss on the Fifth Circuit, Judge Jim Ho, clerked for Clarence Thomas. I've been surrounded by Thomas clerks kind of my whole life. I think he's the greatest living American in this country. He is a true national icon, a hero, and he is really kind of getting out there and I think showing conservatives how to talk about this issue, the big tech issue, and ideally how to legislate on that issue.
And he's really such a lone wolf right now in D.C. to see someone who is just so genuine and authentic and a true critical thinker, as you were saying, in D.C., one of the most liberal cities, unfortunately, in all of America. But I know, for example, critics might come back and they say, OK, so when it came to the gay cake debate in Colorado, in the Masterpiece Cake debate, that for example, Clarence Thomas might have argued that, that a cake baker doesn't have to bake someone a cake that goes against their religious values. However, in this case, they may say, oh, but you say that Twitter or Facebook or other social media platforms should be forced to host content that they disagree with. How would you answer those critics?
Yeah, so I saw people on Twitter making this claim, right? Ari Cohn, who's a lawyer, I think, with Fire, I saw kind of tweeting something along these lines. Ari might have left Fire. I'm not sure where he is now, but he's a libertarian lawyer, and some other libertarians I've seen been making this argument. Look, there are so many differences between the Jack Phillips Masterpiece Cake Shop scenario and gargantuan international global behemoths like Facebook and Twitter that I wouldn't even know where to begin here. Obviously, as far as Masterpiece Cake Shop and kind of the Jack Phillips bake the cake argument are concerned, there are all sorts of other kind of ancillary issues here. There is a sincerely held religious conviction. It is a brick and mortar store. There are property rights issues that kind of come into play here. When we're talking about Facebook and Twitter, Facebook has 3+ billion global users. Google has roughly 90% of the online market share for the search market. Twitter has a lower market share depending on how you define the market, but it is disproportionately influential, of course, in driving the national discussion. And it has banned the president of the former president of the United States, thus kind of showing its clout here. These platforms they're not even comparable to a situation like Masterpiece Cake Shop. The people who are bringing suit against Masterpiece Cake Shop, they could go get that cake anywhere else. I live here in Colorado. I live near Jack Phillips's cake shop. There are hundreds, thousands of other cake shops in the Denver, Colorado area that they could go to get their cake. There are really not any other comparable websites to places like Facebook, Twitter, and Google that you can go seek recourse at if you're banned. So it's just night and day. One truly does seem to me to kind of fit the historical definition on the English common law definition of what a common carrier was meant to be, similar to a railroad or a telephone company. The other, not even close.
Fair enough. And also, we're also seeing from the Supreme Court today a 6-2 ruling in favor of Google in this case when it comes to intellectual property theft. What's your response to this lawsuit?
Yeah, so big day for the tech companies at the Supreme Court. This case has been on the docket for a long time. I wrote an op-ed for the New York Post on this case over a year ago now. Google versus Oracle is billed by many as kind of the intellectual property rights case of the century. Unfortunately, less good news here, at least from my perspective. Justice Barrett recused, but a 6-2 majority of the court rules for Google. From my perspective, what happened here is Google basically just copy and pasted over 11,000 lines of code from Oracle, from Oracle's kind of proprietary Java software, and basically used that to kind of get its Android mobile operating system off the ground. The court basically rules, or they interpret the Copyright Act, basically say that this is what lawyers would call "quote unquote" fair use, meaning that the details are frankly just not worth going into. But the effects of this, I think, are potentially quite bad. The potential effects of this is obviously it's going to disincentivize innovation. Why would Oracle obviously have gone to this? Through all this laborious process of creating 12,000 lines of Java code if Google could just steal it. There are all sorts of kind of national security ramifications here. Obviously, this could possibly aid people in China as far as intellectual property threat. And to that end, there were a lot of briefs filed at the Supreme Court in this case from kind of national security think tanks, basically saying that oracle really should prevail for national security reasons, kind of even holding aside the actual legal merits. So I think it's a very unfortunate result here. Although Justice Thomas, again, did come through in the clutch, wrote a very wonderful, very crisp, precise, and compelling dissent, joined by Justice Alito. So, at least we have two justices who understand intellectual property law correctly.
Were you disappointed at all to see Gorsuch and Kavanaugh side once again with the liberal wing of the justices in this case when it comes to Google?
Yeah, I was disappointed, right? There's definitely no way around that. Some of my friends who actually practice patents law and copyright law say that the case is, they've told me kind of straight up bluntly that the case is from their perspective a little closer than I kind of make it out to be. So maybe there's some sort of principled argument for the other side here that I'm overlooking or neglecting. But yes, the short answer to the question is yes, I find it disappointing here. Justice Thomas and Justice Alito are by far the court's two most consistent conservatives at this point. Justice Barrett, obviously, she's very early on. We don't know a whole lot yet. There are some troubling early signs, but overall is probably too early to tell. Justice Gorsuch, I find this a little perplexing, honestly, because he's a little bit more libertarian-leaning, I guess, than Justice Thomas and Justice Alito, and I would think that a more libertarian-leaning judge or justice would kind of err on the side of wanting to kind of incentivize more innovation, trying to kind of more robustly and staunchly protect intellectual property, which was kind of the thrust of the Justice Thomas dissent in this case. But I do find it disappointing. But yeah, Thomas and Alito are, from my perspective, the two most rock-solid justices, so at least they got it right.
Josh Hammer, always a pleasure having you on to break down these difficult cases. Thanks for joining us tonight.
You bet.